Okay, we left off talking about some ethical considerations, and one thing you'll find about ethics is that ethics are present in every situation you encounter, and a lot of the ethical considerations you make are kind of subconscious. They're drilled into you throughout your life about, right and wrong, a system of belief of how to be. And so we actually offer a class, business ethics, that you'll take if you're a business major. Really good, and we get into talking about some of that stuff. Um, so just wanted to continue down the path of talking about ethics real quick. It says these types of ethical considerations have been addressed by philosophers such as Immanuel Kant, who spoke of the categorical imperative, which is defined as act only according to the maxim whereby you can, at the same time, will that it should become a universal law. Meaning that you want to do things that can be expressed in universal terms and that will be interpreted by other people the same way. And if you're doing things that way, you'll probably be safe in your actions. And so let's talk about e-mediation real quick. It's something the chapter brings up. We're doing a lot of virtual things these days, including this lecture. I've got a friend who does virtual counseling, and instead of she gives clients the option of face-to-face versus virtual, and a lot of them choose the virtual. In fact, earlier this year, I think in March maybe, might have been April, I needed to go to visit a clinic. It wasn't related to COVID, but I just needed to talk to a doctor about a potential illness. And so I called the clinic and asked what they were doing, and they were doing this virtual clinics. I don't know if you've participated in one of these. It's really interesting, and I like it a lot better. Now, I get it. You need to every once in a while, hopefully once a year or at least every other year, go to the doctor and have your physical done where they check your blood levels and just make sure everything's doing like it's supposed to be doing. So I get the need for doing the actual lab work and doing that process. But for casual things like if you've got, a cold or something, or, just some other illness, I really liked the virtual because it saves you from having to go to the clinic and expose yourself to other people that have illnesses. So that was really nice. So anyway, I called the clinic about, I would say an hour and a half later, 2 hours maybe. The doctor called me as a FaceTime call, and I got to have probably a 5 to 8 minute interaction one-on-one with the doctor, which was probably more time than I got when I went for my last in-person physical, because the doctor had an intern who was a new resident, medical school resident, talk to me about basically the questionnaire. And so didn't get a whole lot of FaceTime with the doctor, but with this virtual call I did. So I thought that was really neat. Same thing applies to mediation. You get the same experience that you're going to have in a physical mediation, but you're going to do it virtually. And I think with the pandemic, it's really challenging the way we've done things for a long time. I mean, my kids are going to school virtually right now. A lot of you are doing at least partial virtual school. I could see a day where, the trend has been more and more online focused in the past couple decades. When I started my master's degree, I'm trying to think of the year, probably would have been 2006, 7, 8 range that I started it. It was very taboo. It was a little less taboo than it was earlier than that, but it was still taboo to go to get a degree in an online environment. Nowadays, every institution of higher learning, if you're not offering online classes, especially in this environment, you're out of business. You're closed. You can't operate without offering online components. So what once was taboo and abnormal is now very much a norm. And so education at the end of the day, too, is what you put into it. What you put into it is what you'll get out of it. The inputs that you put in to a process will greatly determine the outputs that you receive. And so I'm going to let that go to voicemail. I'll call them back. So e-mediation, we've talked about that briefly. Just the same thing, but just a different way of delivering that information. So arbitration. This is the last big topic I wanted to talk about. I normally would, if that's you calling me, normally I would pick that up, but I am doing the recording. So, but arbitration, the American Bar Association defines arbitration as the private process where disputing parties agree that one or several individuals can make a decision about the dispute after receiving evidence and hearing arguments. Arbitration is overseen by a neutral arbiter or an individual who is responsible for making a decision on how to resolve a dispute and who has the ability to decide on an award or a course of action that the arbiter believes is fair given the situation. This is a key distinction from mediation and negotiation. Arbitration is a binding agreement. You're saying that if I go to an arbitration, whatever the arbiter decides is binding. That's the outcome. So it's very different from mediation in that you're basically relinquishing control of the outcome to a third party. This brings up this thing called the mandatory arbitration clause. A lot of you are already involved in mandatory arbitration clauses and you don't know it. So anytime that you sign up for an app or sign up for services like iCloud or Apple, any type of Apple service, or I'm sure the same is true with Android services. Anytime you sign up to purchase a cell phone, any type of a contract that you go into these days, most of the time is going to have what's called a mandatory arbitration clause. The reason why they have mandatory arbitration clauses is because companies do not want to go to court. They don't want to go to court because when they get sued and they go to court, it's a liability for them. They have to pay legal fees, very costly, time consuming. And so they would rather have an arbiter that they pay making the decision. So think about this. It's supposed to be a neutral arbiter, but if the company that has made you sign, or well, it's providing you goods and services, and for those goods and services you signed a contract or agreed to a contract whereby you say, I'm going to do, if there's any problems, we're going to have mandatory arbitration. Basically, what you've done is given up your right to trial, to go to court. And a lot of times people don't think about that or even care about it until they need it. So, you know, when you sign up for a good or service, there's all these things that you're supposed to read that nobody does. It's a lot of legal jargon. And hidden in that legal jargon somewhere, there was this thing called a mandatory arbitration clause. You signed up for it, you agreed to it, you relinquished your rights to go to court, to have a judge or jury or both make these decisions. That's how the outcome's going to be. So imagine that you use a product for several years, and all of a sudden we find out this product causes cancer or causes some type of harm in some way, and then you can't sue the company because you signed or agreed to a mandatory arbitration. So what happens? You say, okay, well, I agreed to it. I didn't know about it, but I agreed. So you go to arbitration. What ends up happening? The arbiter is paid for by the company, and so how do you think that's going to go? Do you think the arbitration company has a vested interest in deciding to decide things for or against you? Keep in mind that their payday comes from the company, and they don't get anything from you. So how can they be neutral? They can't be. They're very much impartial. They can't very much non-impartial, or they can't be impartial because of that. that conflict of interest they have. They're paid to basically decide things, but I would surmise that if you went and really studied arbitration, and I have not done this, but I'm hypothesizing that if you went and studied arbitration results, you would find that in the majority of cases, the arbiter sided with whatever company was paying for their services. And so that is interesting, you know. And so I get why arbitration is interesting, but keep in mind that in our society today, these binding arbitration agreements, it mentions it right here on page 23 in Chapter 2, are very much kind of can be a problem because if there's a really good example of this in a documentary called Hot Coffee. I've shown this in class before. You can look it up online. It probably is available for free through one of the streaming services. Hot Coffee is a documentary about several cases. One of the cases was when an older lady had coffee that she got from McDonald's. It spilled on her, caused second and third degree burns. She sued, ended up getting awarded something like $2 million. But that's an interesting case. Look at that case just to learn about it if you haven't. But also look up the I can't remember her name. Her first name is Jamie. She went to work for a company called Halliburton, and during her she was told when she signed up that she would be sent abroad. She knew she was going abroad, but she would have an all-female bunk and she would be safe. And within 24 hours of her getting to where she went to work on an outpost in Iraq to facilitate things like infrastructure. That's what she was there to do. But within 24 hours, she was beaten and raped. And because of the mandatory arbitration, she could not seek out damages from the company because she had basically signed away her rights to take that company to court for basically putting her in an unsafe environment. And that is a really tough case to look at. I'm not going to tell you the outcome. I want you to go look it up. Hot Coffee's the documentary. Jamie is the name of the plaintiff, somebody that has an issue, and the company was Halliburton she worked for. So there's a lot of different use cases for arbitration: labor, grievances, business transactions, property disputes. So typical civil disputes, as opposed to criminal matters, attempt to use arbitration as a means of dispute resolution. While definitions can vary between municipalities, state, and countries, a civil matter is generally one that is brought when a party has a grievance against another party and seeks monetary damages. In contrast, a criminal matter, a government pursues an individual or group for violating laws meant to establish the best interest of the public. And so there's some great reading on the ethics of arbitration, but in the interest of time, I want to just kind of end there, and it does get to the chapter summary after another couple pages. Well, this PowerPoint, or this presentation, I'm sorry, whether it be the video or the podcast, this was designed to kind of introduce you to Chapter 2, kind of go through some of the high points. I would like you to go in and do the reading. There's some finer points that we did not cover just for time purposes, but I do want you to go back, do the reading, familiarize yourself with these concepts. Don't forget to start your homework. Chapter 3 homework is due this week. And if there's anything I can do to support you, any questions I can answer, please let me know. Email is the best way to get me. But for now, I appreciate your time, and we'll talk to you soon.